Aris Jayaraj versus GST. What every artist should know about tax notices. Hello everyone. Welcome to the Arinath Law Firm's YouTube channel. I am Advocate Arinath and today we are talking about a case that every artist, musician and creative person should know about. It involves the famous musician Aris Jayaraj and it is about the legal challenge he faced over a GST show cause notice. This case is titled Aris Jayaraj versus the Joint Director and others with the case number WP number 28060 of 2019. Why is this important? Because many artists like Aris are getting these notices and it can be really confusing to know what to do next. So let's break it down in simple terms. Aris Jayaraj, one of the India's top music composer, received a show cause notice from the Director General of GST Intelligence. This notice questioned whether Aris had to pay service tax for his work as a musician. The notice came under Section 73 of the Finance Act 1994, which talks about service tax for services provided. Now, here is the big issue. Aris Jayaraj argued that the work he did was already permanent, meaning he transferred all his music rights to the producers of the film he worked on. So, he felt there was no service left to tax. He even pointed to other cases where such notices were squashed or thrown out by the courts. But the Madras High Court looked at things differently this time. So, what did the court say? The Madras High Court under Justice R. Suresh Kumar and Justice C. Saravanan made an important decision. They said you can't directly challenge a show cause notice in court. Here's what that means in simple terms. If you get a show cause notice, you can't just go to court and say, I don't agree with this. Instead, you need to reply to the notice and present your objection to the adjudication authority or the officials who issued the notice. In Aris' case, the court said he should give his reasons to the GST department and they would decide if the tax was owed. The court also gave the department a time limit of 4 weeks to review his response and make a decision on. This ruling followed an earlier decision from a similar case involving Underbar Films. In that case, the court said the same thing. Show cause notice have to be handled by the proper authorities first, not the courts. So, why does this matter for you, especially if you are an artist or musician? Well, a lot of creative people may not realize that the services they provide can be taxed under GST. If you have signed contracts for your work or transferred your rights, you might think you are in the clear, but the tax authorities could still send you a notice. What you need to know is, if you get a show cause notice, don't panic. You can reply to the notice with your objections. If you are unsure, seek legal advice so you know how to respond. Aris Jayaraj case shows us that even well-known artists can face these challenges. It is all about knowing your rights and handling things the right way. So, to sum it up, the court didn't tell Harris Jayaraj avoid the GST notice, but it gave him the chance to explain his case to the tax authorities. This is a big reminder for the artists to be aware of how their services are taxed. Always make sure you know the law and don't be afraid to ask for help when needed. At Arinath Law Firm, we are here to guide you through legal issues like these and help you protect your work and your income.